matter of State of Ohio versus Leland Talley, case number 25CR000475. The defendant is present in court with defense counsel William Mooney. We are here for purposes of a information hearing. On July 21st, 2025, a one-count information was filed against the defendant, that one count being attempted having weapons while under disability, a felony of the 4th degree in violation of revised code sections 2923.02 and 2923.13A2. It is my understanding today that the defendant wishes to withdraw his previously entered plea of not guilty, sign a waiver of his right to have his case presented to the grand jury, and enter a plea of guilty to that one count in the information. As part of plea negotiations, there is a joint recommendation for community control at sentencing between state and defense. Thank you.
Thank you. Mr. Mooney, does that sound accurate?
Good morning, Your Honor. Yes, it does.
Thank you. And Mr. Talley, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to waive your right to have the case presented to a grand jury, and I'll explain that in more detail here, what that really entails. And then you're going to go ahead and plead guilty to the charge and the information, which I will also review with you to make sure you understand that. We will then continue the sentencing to a future day to get some evaluations completed, come back on a future date, where there will be a joint recommendation at the time of sentencing presented to the court that you be placed on community control sanctions. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do this morning?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
46, Your Honor.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, Your Honor.
Okay. Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the charge?
No.
You never got a copy of it? You never received a copy of that, Mr. Mooney?
No, it was emailed to me, Your Honor, and I did explain it to Mr. Talley. I don't know that I actually showed him a visual copy of that.
You have one there? Make a copy of that stamp, please.
Do you want a copy?
Yes.
No, gee, we already went over it over the phone, and then I just didn't make a copy for him. Oh. Apologies, Judge. We talked about this. This is one count. Understand?
Right.
So, Mr. Taylor, you've had a chance to look that over?
Yes, Your Honor. And this is what I did review with Mr. Talley over the phone, and he acknowledges that this is what we talked about.
Is that correct, Mr. Talley?
Yes, Your Honor.
Well, I'm going to review, make sure you understand the charge, and if you have any questions, make sure you ask. What's alleged here and what you'll be admitting to is on or about March 12, 2025 in Willoughby Lake County, Ohio, that you did purposely or knowingly and with sufficient culpability for the commission of the offense of having weapons while under disability, a violation of 2923.13.8.2 of our revised code. That you engaged in conduct that, if successful, would constitute or resulted in the offense of having weapons while under disability in violation of that revised code section. Specifically, what having weapons under disability means is that you knowingly acquired, had, carried, or used a firearm, and you were under indictment for or previously have been convicted of a felony offense of violence. In this case, specifically, you were convicted of the offense of felonious assault in Cuyotta County back in 2009, which is a felony offense of violence. So that latter part of what I just explained to you is what having weapons under disability constitutes. You're pleading guilty to, for purposes of the plea today, engaging in conduct that, if successful, would have resulted in that. And the significance of that is that it reduces it from a felony of the third degree to a felony of the fourth degree. A felony of the third degree is much more serious than a felony of the fourth degree in terms of potential penalties you face. So what you're pleading guilty to is, again, knowingly engaging in conduct that, if successful, would have resulted in the commission of the offense of having weapons while under disability. Do you understand that?
Yes, Your Honor.
Any questions for me about that?
No, Your Honor.
Well, before I can accept your plea, then I need to make sure you understand the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So that document I just read to you that you were given is called an information. And what an information is, it's a criminal charge brought by the prosecutor's office without the case having previously been reviewed by or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that will get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that a person committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Now, everybody here in Ohio, when accused of a felony, has the right to have a grand jury independently review that evidence and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can give up or waive that right if you desire and go forward in the charge brought by the prosecutor and the information, and your attorney has represented he believes that's what you want to do here today. Is that correct?
Yes, Your Honor.
Well, before I can go any further on the information, I need to have you acknowledge that here in open court in writing. And I have in my possession at this time a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just gone over with you regarding that grand jury process. Again, before I can go forward, I need to make sure you understand the document and you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over that one-page document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Mooney, is that accurate? Did you review this with Mr. Talley, read it over with him, answer any questions you may have had?
Yes, I did, yeah.
And in doing so, did he indicate an understanding of that document to you?
He did.
Is that correct, Mr. Talley?
Yes, Your
So you
Honor.
understand what it says?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
It also appears that you signed the document. Did you in fact sign it?
Yes, Your Honor.
And Mr. Mooney, you witnessed that?
I did.
Ms. Ronick, you as well?
Yes, Your Honor.
All right, I will make that document part of the record. At this point, Mr. Talley, I'm going to review with you all the other rights you have that you are giving up by pleading guilty. And you first of all have a right to a trial. And a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. Unanimous means that all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. You understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, you'd have the right to have an attorney represent you at the trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Excuse me. Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of this charge. That presumption of innocence sticks with you and stays with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I read to you beyond any reasonable doubt before you could ever be found guilty of that charge. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the state prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, if we had a trial, the prosecutor would bring witnesses into court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask you questions. We call that, your lawyer would have the right to ask those witnesses questions. We call that cross-examination. He could ask them anything he wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to by answering your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. That order is what we call a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she wouldn't be allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer couldn't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have, all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts that are being alleged by the prosecutor. We're not going to argue later you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you're going to be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the fourth degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. You understand that?
Yes, Your Honor.
Now, you currently on probation or parole, post-release control, any type of supervision, any other courts or agencies?
No, Your Honor.
Do you have any other criminal charges pending against you anywhere?
No, Your Honor.
If a prison sentence is imposed in this case, if a prison sentence is imposed in this case, upon your release from prison, you could be placed in what's called post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you served and completed whatever prison sentence was imposed. And in this particular case, it's not mandatory, but it could be imposed by the parole authority for up to 2 years. Do you understand that?
Yes, Your Honor.
And if you are placed on post-release control and you ever violate any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence that I just reviewed with you, there's other sanctions or penalties that can be imposed. You could be fined up to $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. I did use the word possible. Prison is not mandatory with this charge. You are eligible for probation, what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Now, do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that. If that's what you're requesting. It appears that you are. And I'm certainly going to consider that. Look at all the information that gets presented, but I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions, it could be for up to 5 years. And as the judge, I had the discretion to order a wide variety of different rules and conditions for you to follow. One of the conditions of community control sanctions could be in order that you serve a term in the Lake County Jail of up to 6 months. Now, it doesn't have to be, but I need to make sure you understand that even if you're put on probation, that doesn't mean there's no jail time. Doesn't mean there is, but you could still be incarcerated locally in the county jail for up to 6 months. Do you understand that?
Yes, Your Honor.
Further, if you're on community control and you're violating the rules or conditions of your supervision, we will have a hearing to see if you're what's called a probation violator. And if it's determined that you are, I could extend your community control up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, or I could terminate your community control and send you to prison at that point. If I did it then, again, it could be anywhere from 6 to 18 months in prison, and that could be consecutive to any other sentence you may be serving for some other new case that you pick up or you're being sentenced to on that day. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time in this case to review the case with your lawyer, have him go over the report with you, discuss issues, answer whatever questions you have?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would establish at a trial if we did have a trial. I want you to listen to her because I'm going to ask some follow-up questions for you about that, all right?
Yes, Your Honor.
Ms. Ronick.
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on March 12, 2025 in Willoughby Lake County, Ohio, the defendant did purposely or knowingly and with sufficient culpability for the commission of the offense of having weapons while under disability engage in conduct that, if successful, would constitute or result in that offense, and also that the defendant had been convicted of a felony offense of violence, specifically felonious assault, in the Cuyahoga County Court of Common Pleas, case number CR 09-523909, dated July 21st, 2009. Specifically, Your Honor, on March 12, 2025, at about between 3 and 3:20 a.m., the defendant was at the Sheetz gas station in Willoughby Lake County, Ohio. There were several other individuals at the gas station in which the defendant engaged in some form of verbal altercation with. The defendant, feeling threatened by those individuals, drove out of the Sheetz gas station in his vehicle, and as he was exiting the Sheetz gas station, discharged a firearm into the air 2 times. The state would also prove that specific prior conviction for the defendant, in that in July 21st, 2009, the defendant was convicted in Cuyahoga County Court of Common Pleas of felonious assault.
Where did this occur?
The Sheetz in Willoughby.
Why was this reduced?
I'm sorry?
Why was this reduced?
Well, there are several factors to the reduction. The defendant was apprehended because the police department put a photo from the surveillance footage on Facebook. The defendant turned himself in on that photo and admitted to everything. Nobody at the gas station was particularly willing to cooperate with police or give statements as to what they saw. The firearm was not recovered, and the...
Why is that a positive?
Sorry?
Oh, if you're talking for evidence purposes.
Right.
Gotcha.
And the detective in the case had made a pitch at municipal court level to actually have it reduced to a misdemeanor. That pitch was denied by the prosecutor, but the detective did inform me of that and my office and stated that the defendant was the most cooperative defendant he has ever interviewed in his career.
It's just that you normally don't reduce these, and in this case you have someone that actually discharged a gun. But. All right, Mr. Talley, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, did they say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor, I did.
Where's the gun?
I don't have it.
I didn't
wasn't
ask
mine,
you
Your Honor.
if you had the gun. I said, where's the gun?
Oh, it was back to the person that it belonged to. I gave it back right after that.
Very well, then regarding count one here, charging with attempted having weapons under disability, a felony in the 4th degree, what is your plea to that count?
Yes, what the plea was.
Judge, can the court repeat the question?
So regarding count one here, this information, charging with attempted having weapons under disability, a felony of the 4th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which explains everything we've just gone over here. Your rights you're giving up, penalties you face, what you're pleading guilty to. Before I can accept your plea, I need to make sure you understand the document, what it says, and that you sign it here in court. Now, my understanding, again, is that you had a chance to go over this with your lawyer prior to me coming out here. Is that correct?
Yes, Your Honor.
Mr. Mooney, is that accurate? Did you review this again with your client, read it over with him?
I did, Your Honor.
Did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Talley?
Yes, Your Honor.
Any questions for me about what the document says?
No, Your Honor.
And it appears you signed it. Did you in fact sign it?
Yes, Your Honor.
And again, Mr. Mooney, did you witness that?
I did.
Mr. Ronick, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count one, attempted having weapons while under disability, a felony of the 4th degree in violation of 292302 and 2923.13A2. The court will defer sentencing and order a pre-sentence report and investigation. Any issues with drugs or alcohol that need to be explored?
Not
No.
that I'm aware of, Your Honor.
Okay.
No.
Then we'll just do a pre-sentence report. I'll set defendant's bond at owner cognizance. That's what it was, correct?
Yes, it was.
Okay. I saw the paperwork was signed. So what all this means, Mr. Talley, as far as bond goes, and basically continuing the bond that you already had. An owner cognizance bond means you have to show up at all future court dates. And if you don't appear at a court date, that's a separate felony, which is actually the same level that you just pled to in this case that you would be prosecuted for. So it's obviously important you show up at all future court dates. And your sentencing is, when's the sentencing, Mr. Shadowin?
It's going to be, 9/8/25, 10:45.
So September 8th at 10:45?
Yes, sir.
You got that?
Yes, Your Honor.
All right, so you need to make sure you're here for that. But before we get to that point, there's going to be some, like I said, a pre-sentence report being prepared. And for the probation department to be able to prepare that report, they need to have an interview with you. And they're going to set up a meeting with you. It's important, first of all, that you show up when you're supposed to, because if you don't, and they can't conduct the interview, then they can't do a report. Without a report, the law doesn't even allow me to consider probation as an option. Also, you need to make sure you're open and honest with them when you're meeting with them, because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they would certainly let me know that, and I'll consider that at sentencing. Also, one of the conditions of your bond is that you don't use any drugs while on bond, and you may be requested to submit urine screens. If so, you must submit those. They must be negative. A positive screen will result in your bond being revoked and a warrant being issued. Do you understand that?
Yes, Your Honor.
Okay. So you're going to leave here right now. You're going to go to the probation department. Do you know where that is?
No, Your Honor, my lawyer had
Do you know where it is?
I'll take him over here.
Okay,
Your
third floor over there. You're going to fill out some initial paperwork and get your date to come back for that interview. So make sure you go there when you leave here right now, all right?
Yes, Your Honor.
All right. Mr. Mooney, anything else?
Honor. Nothing further.
Mr. Horonic?
No, Your
R000434, State of Ohio versus Brian D. Wilson. Present in court is the defendant, who's accompanied by his attorney, Ms. Nicolette Tomazik. Your Honor, it's the state's understanding that the defendant is prepared to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 4, aggravated possession of drugs, a felony of the 5th degree, as well as count 5, tampering with evidence, a felony of the 3rd degree, with a voluntary forfeiture of all seized contraband and instrumentalities. The state would move to dismiss the remaining counts of the indictment at the time of sentencing. There is no recommendation or agreement with regard to sentencing at this time, and full discovery has been provided. Thank you.
Ms. Tomazik, does that sound accurate?
That is all accurate, Your Honor.
And Mr. Wilson, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of guilty to a couple of the counts in this indictment, plead guilty to those charges. The other counts will get dismissed. We would continue the sentencing to a future day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
It is, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
I am 47 years old, Your Honor.
Are you able to read and write the English language?
I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
I do not.
Are you a U.S. citizen?
I am.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
I have not, Your Honor.
Not even prescribed medication, nothing?
I have not taken even my prescriptions.
I'm sorry?
I have not even taken my prescriptions.
When's the last time you took any prescribed medication?
5 days ago.
Okay, what is that?
I am prescribed Vyvanse, but
Okay.
I was afraid they might come up as an amphetamine, so I just haven't been taking them.
Well, make sure you still, probably won't come up, but make sure you let probation know what prescriptions you have, give them proof of that, so that if it does come up, 5 days is probably right on the
That's what it said.
right on the edge. But make sure you let them know whatever prescriptions you have. So nothing within the last 48 hours, though. So there's nothing right now that could potentially be affecting your ability to understand or appreciate where you are or anything like that, correct?
That's correct, Your Honor.
Now, you would have received a copy of this indictment back in, looks like the beginning of May. Remember the document that sets forth the charges?
Yes, Your Honor.
Do you have a chance to look that over?
I have.
Now, in the indictment, as I indicated, there's counts. You're pleading guilty to 2 of those, so I'm going to go over those 2 charges with you. If you have any questions, make sure you ask. But in count 4, what's alleged here is on about, March 23rd, 2025, in Kirtland Lake County, Ohio, that you didn't knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance which contains methamphetamine, which is also a Schedule II controlled substance. The amount of the methamphetamine was less than the bulk amount, which means its offense is aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in count 4?
I do, Your Honor.
Any questions about it?
No, Your Honor.
Now, in count 5, what's alleged here and what you're admitting to is on or about March 23rd, 2025 in Kirtland Lake County, Ohio, that you, knowing an official proceeding or investigation was in progress or is about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with in pleading guilty to in regards to count 5?
Yes, Your Honor.
Any questions about that?
I do not, Your Honor.
Now, there are 3 other counts of this indictment, excuse me, that are being dismissed pursuant to the agreement. Is that your understanding?
That is.
Any questions for me about those 3 charges?
I do not.
Well, then before I can accept your plea of guilty to counts 4 and 5, I need to make sure you understand all the rights you are giving up. And you, first of all, have a right to have a trial. And a trial could be to me as a judge, where I would listen to all the evidence presented, then I'd make the decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
I do.
You understand by pleading guilty you're giving up your right to have a trial?
I do.
Now, if we had a trial, prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, she bears the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
I do, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
I do, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the state prove you guilty at a trial?
I do.
Now, in order to do that, or at least try to do that, if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
I do.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
I do.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
I do, Your Honor.
And you further can request the court issue an order. That order is what we call a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own. Do you understand that?
I do.
Do you realize you're giving up that right?
I do.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision that you and you alone would have to make. Do you understand that?
I do.
And since that's solely your choice, what that means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you did not want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
I do.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal any guilty finding I'll make if I accept your plea, as well as any other issues that you could have raised or brought to my attention up to this day. Do you understand that?
I do.
All right. Well, do you have any questions regarding any of these rights we've just discussed?
I do not, Your
You
Honor.
understand them all?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
I do.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
I do.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree and a felony of the 5th degree. The possession charge in count 4 is a 5th degree. That is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
I do.
Now, in regards to count 5, the tampering with evidence charge, it's a felony of the 3rd degree. That is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, 30. So if a prison term was imposed, it'd have to be one of those numbers, 9, 12, 18, 24, 30, or 36 months, and that's be the amount of time you have to serve for count 5. You understand that?
I do, Your Honor.
Now, since there's 2 separate charges here, if I impose the prison sentence, I'd impose it on each count. Then as the judge, I have the discretion to run those prison terms either what they call concurrent or consecutive to each other. Concurrent means together, serving them at the same time. Consecutive is one after the other. You serve the prison term on count 4, complete it, then the term on count 5. You understand the difference there?
Yes.
So in this particular case, if I gave you the maximum sentence in the 2 counts you're pleading guilty to and ran them consecutive, you're looking at a maximum possible prison term of 48 months or 4 years. You understand that?
I do, Your Honor.
Now, you currently on probation or parole to any other courts or agencies?
I am not.
Do you have any other charges, criminal charges, pending against you in any other court?
I do not.
If a prison sentence is imposed in this case, upon your release from prison, you could be placed in what we call post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. In this particular case, it could be up to 2 years. Do you understand that?
I do.
And if you were put on post-release control and ever violated any conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by the court. Do you understand that?
I do, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined in this case. Count 4, the possession charge carries with it a possible fine of $2,500. Count 5, the tampering with the evidence charge carries with it a possible fine of up to $10,000. So altogether, there's a maximum fine of $12,500. You understand that?
I do, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
I do.
There's also a possible driver's license suspension that could be ordered regarding the drug charge of up to 5 years. Do you understand that?
Yes, Your Honor.
Now, a few moments ago I explained the possible prison sentence, and in doing so I used the word possible. Prison's not mandatory or required with these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand just because you're eligible doesn't mean it's automatic that you're going to be put on probation? It means it'll be considered by the court. I'll look at all the information presented, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your
Now, if you are put on community control, it could be up to 5 years of supervision. And as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, Your Honor.
Further, if you are on community control and you're violating any of the conditions of your supervision, we'll have a hearing here in court to see if you're what's called a probation violator. If it's determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison then. And if I did it at that stage, again, it could be up to 48 months in prison altogether. Do you understand that?
Yes, Your Honor.
And that could be consecutive to any other case that you may be serving at that time, or new term that if something happens since then. You understand that?
Yes, Your
All
Honor.
right. Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf, recommend a sentence to court. The prosecutor is also allowed to recommend a sentence to the court. Do you understand that?
I do, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
I do.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
I do.
Do you still want to plead guilty?
I do, Your Honor.
Have you had enough time in this case to go over everything with your lawyer, have her review the reports with you, discuss the issues, answer whatever questions you may have?
I have. She's been very forthcoming.
She's what?
She's been very forthcoming. I have.
Good. Are you satisfied with the advice and counsel of your lawyer?
I am.
Has she or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
I am.
All right, then. Do you have any questions for me at this time regarding anything that we've discussed? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
I do not, Your Honor.
Do you need any more time to speak with your lawyer any further before we go forward with your plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I'll have some follow-up questions for you, all right? Okay?
Yeah, oh, yes, Your Honor.
All
Sorry.
right. Ms. Himmeline.
Thank you, Your Honor. Had the matter proceeded to trial, the state would establish beyond a reasonable doubt that on March 23rd, 2025, in the city of Kirtland, Lake County, Ohio, police initiated a traffic stop on a vehicle in which the defendant was a passenger and where drugs and paraphernalia were located. At the police station while the defendant was being booked, during an official investigation, he was seen on video manipulating his foot and pant leg until a small plastic container fell out, at which time he kicked it under the desk in an effort to hide it. The container was collected and sent to the Lake County Crime Lab for testing, and it was confirmed that it did contain methamphetamine residue, a Schedule II controlled substance. For purposes of the forfeiture specification, Your Honor, there was also psilocybin and paraphernalia.
There's no
that was seized.
specification.
I'm sorry, voluntary forfeiture.
Oh,
I'm sorry, I misstated that. For the voluntary forfeiture.
Mr. Wilson, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
I have.
What, if anything, did to say about those facts as she presented them? Are they accurate? Did you do what she said?
Yes, Your Honor.
Very well, then regarding count 4, charging with aggravated possession of drugs, those drugs being methamphetamine, this is a felony of the 5th degree, what is your plea to that count?
Guilty, Your Honor.
As for count 5, charging with tampering with evidence, a felony of the 3rd degree, what is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything we just talked about. Before I can accept your plea, I need to make sure you understand the document, that you sign it here in court. My understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
That is correct, Your Honor.
Ms. Tomazik, is that accurate? Did you review this with Mr. Wilson? Answer all his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Wilson?
It is, Your Honor.
Any questions for me about this document?
I do not.
It also appears that you signed the document. Did you in fact sign it?
I did.
And Ms. Tomazik, you witnessed that?
Yes, Your Honor.
You as well, Ms. Himmeline?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 4, aggravated possession of drugs, a felony of the 5th degree in violation of 292511 of the revised code, and count 5, tampering with evidence, a felony of the 3rd degree in violation of 2921.12. I will defer sentencing. The rest of the counts are going to get dismissed at sentencing, but we're going to continue sentencing in order of pre-sentence report investigation, drug and alcohol evaluation, and continue defendant's bond at $25,000, cash surety, or 10%. So what all this means, Mr. Wilson, as far as bond goes, that's not changing at all. Your bond's remaining the same, which includes conditions of bond, which one is that you do not use any drugs while you're on bond. You have to submit urine screens if they're requested. They must come back negative. Again, we talked about make sure you bring a prescription to show them for the Vyvanse. But they should come back positive. Your bond will be revoked and a warrant would be issued if it's something that's not prescribed and illegal. Includes marijuana. Now, the purpose of this report is so that I can learn more about you before sentencing. The way the probation department gathers the information they need to prepare the report is they're going to conduct an interview with you. It's important that when you meet with them, you're open and honest, first of all, because they're going to check and verify everything you tell them. And if they learn you're misleading them, they're going to let me know that, and I'll consider that. Also, in order to do the report, the interview with you has to take place. That means you have to show up when you're scheduled for that interview. If you don't, then they can't do the report. Without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, Your Honor.
So you're going to leave here right now. You're going to go right to the probation department, meet with them, fill out some initial paperwork, and get your date to come back for the interview. So make sure when you leave here, you go directly there to get the ball rolling, all right? Okay. I think that covers everything. Ms. Himmeline, anything else for the record?
No, Your Honor, thank you.
Ms. Tomazik?
No, Your Honor, thank you.
All right, thank you.
All rise.
CR 824, State of Ohio versus Pindo, aka Pinduli, Kreitz, aka Napatopulu. The defendant has been charged in a 10-count indictment, including 5 counts of tampering with records, felonies of the 3rd degree, and 5 counts of forgery, felonies of the 5th degree. We're here today for the purposes of a pretrial hearing. The state has tendered an offer to the defendant. If the court would like me to place the terms of that on the record, I would be happy to do such.
1 second. Okay.
The state would be happy to offer the defendant a plea to count 1, tampering with records, a felony 3, and forgery, count 2, a felony 5. We would merge the properties from count 3 and 5 and 4 and 6 into those counts respectively. And then count 7, tampering with records, a felony 3, and count 8, forgery, a felony 5, merging the property from count 9 and 10 into those.
So count 1 and 2 and 7 and what? 8?
7 and 8. We would then move to dismiss counts 3, 4, 5, 6, 9, and 10, and the state would agree to jointly recommend community control sanctions. Thank you.
Can you give me a brief summary about what this is about?
Your Honor, this is regarding a number of quitclaim deeds. There were 5 separate properties that had notarized quitclaim deeds. It is the state's contention that the defendant falsified these quitclaim deeds and forged her name to be on those deeds and then transferred those properties into the name of another following the death of her husband.
Thank you.
Thank you.
All discovery has been provided?
Yes, all discovery has been provided to defense counsel.
Thank you. Ms. Tomaszek, anything you'd like to add? You don't have to in regards to the facts or anything, but anything you want to add in that regard?
Not at this time, Your Honor. Thank
You have received discovery?
Yes, I received discovery.
Okay. Any potential suppression issues or any other issues that would require an evidentiary hearing being scheduled?
No, Your Honor.
Any history, Ms. Tuttle, with the defendant?
No criminal history, Your Honor.
So the last name is pronounced, how do you pronounce it? Kreitz? Kreitz?
Correct.
Kreitz. Ms. Kreitz, you have been released on an own recognizance bond. So we had the pretrial. The purpose of this pretrial is for me to just learn about what the case is about, because I don't know anything about it until this very time. Find out what the state is willing, if anything, to make an offer to try to resolve it. Make sure that's been communicated. Make sure there's no other issues that need to be resolved, and that discuss anything we need to discuss. The next step for my purposes, the matter is set for a trial in a couple months, September 23rd. And then there may be other things that you're going to have to deal with your lawyer and going back and forth with them. I'm not involved in any of that. But you're required to be here for trial on September 23rd. And when you're released on an own recognizance bond, you have to show up at all future court dates. If you fail to do that, that's a separate felony that you can be prosecuted for, separate and apart from anything we're here for right now, which could involve an additional potential 18 months in prison. So it's obviously important you show up at all your future court dates. Now, as I said, the next date is the trial on September 23rd. However, if this case is going to be resolved in some fashion, by way of some type of a plea, that will happen before September 23rd. You will be required through your attorney to notify the court at least 2 weeks before the trial date whether you want to accept the state's offer or not. So that should be, what, September 9th, I believe. Make sure I'm right. September 9th. So we will need to be notified on or before September 9th as to whether you intend on accepting the state's offer or not, and if it's going to be a plea. If it is, it will be before the trial date. It will be before September 23rd. So if that's the case, we'll be letting your lawyer know when the trial date is. You need to make sure you find out from her when that is. She'll send a notice, but if you don't hear anything, don't say I didn't hear anything, and so I just came on September 23rd, because that's not, it'll be before that. All right, so it's your responsibility to make sure you keep up to date as to when your hearing dates are. All right? All right, is there anything else we need to discuss, Ms. Tuttle?
Not from the state, Your Honor. Thank you.
Ms. Tomaszek?
Not at this time, Your Honor. Thank you.
Thank you.
All rise.
We're here today for sentencing in the matter of the State of Ohio versus Anthony E. Buchanan, case number 25 CR 802. Mr. Buchanan is present today in open court with his attorney, Ms. Nicolette Tomazik. At the last proceeding, which was held on June 30th of 2025, the defendant pled guilty to one count, that being theft, felony 5 under 2913.02A1. Your Honor accepted the plea and ordered that the defendant undergo the PSR evaluation. Your Honor also ordered a victim impact statement. We have read the PSR. We are ready for sentencing. There is no prior agreement as to sentencing, Your Honor. It appears that the defendant has 66 days of jail time served to date, Judge. Thank you.
Thank you. Ms. Tomazik, any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing today.
Anything you'd like to say at this time on behalf of your client?
Yes, thank you, Your Honor. We'd like to ask the court to give Mr. Buchanan an opportunity on community control sanctions today. And speaking with Mr. Buchanan with regards to conversations we had in chambers, he indicated to me that if Your Honor were to place him on community control, he would be open to participating in NeoCap. He did recently complete CBCF. He did say he received some benefit from it, but he said he could always use some more help with everything. He's very open to completing NeoCap and doing whatever he needs to do if you allow him an opportunity on probation. Your Honor, he also does have 6 children. Most of the kids do live with their mothers. However, he does have an 8-year-old son at home. His 8-year-old is currently with his mother, though. Mr. Buchanan does live with his mom full-time. He does assist his mother, and he does help out with rent when he's able to. Prior to this, he was employed at Team Wendy, so upon release from whatever sanctions are imposed, it is going to be his top priority to find new employment and be there for his children and be a good example for his children. I know Mr. Buchanan has had a prior prison stay for his felonies in 2016, and there was a couple parole violations on there. But in speaking with Mr. Buchanan, he's fairly confident in himself that he'll be able to complete any and all terms if Your Honor were to give him probation today. So we just like to ask the court to give Mr. Buchanan an opportunity to complete probation, possibly get into NeoCap if that's what Your Honor would like for him to do. Thank you.
Thank you. Mr. Buchanan, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, sir.
Go ahead.
May I stand?
Whatever you're comfortable doing.
If my victim was here, I would first and foremost like to apologize for taking their wallet. It's not in my character, to be honest. Today, I stand here willingly taking a guilty plea because I know right from wrong. I'm asking you for an opportunity, or asking you, Your Honor, for an opportunity to help me redeem my character, or give me an opportunity to redeem my character so I can show my children, or my sons most importantly, a man with integrity. That being said,
Why are you so confident that you're going to be able to do this? Because you haven't been able to before in the past. Every time you've been on any supervision, you violated. You're on probation, you violated. You're on probation, you violated. You're on parole, you violated several times. I mean, this happened 2 weeks after you got off parole. I don't get where this confidence is coming from that you have, that you think you can do this when you've never done it.
well,
And you've been given chances to do it.
well, I feel like I can do it because I've recently just had a child, and
You have
I've
6
been talking-
kids.
Yes,
How's the oldest?
12.
All right, so you had a kid 12 years ago.
Yes, 13. Yes.
And then 5 more before that. Having a child didn't spark anything here in the past.
Well, my process was slow, but eventually I have been growing, not as fast as I should have, but I've been growing to do better. Yes.
And you were just terminated from parole 2.5 months ago, right?
Yes, sir.
And you committed this afterward. Where's the growth you're talking about? Where's that? When did that happen?
Well, the death of the wallet really came from not being financially stable completely. Like I said, I know it's wrong. It's not nothing that I want to teach my children, but I'm going to take responsibility for what I've done.
Is there anything else you want to say?
So,
Be seated.
thank you.
Ms. Thomas, is there anything else for the defense?
Not at this time, Your Honor. Thank you.
Mr. Tavanche for the State of Ohio.
Yes, Your Honor. It is clear that any presumption for CCS has been overcome. The defendant has prior prison, has noted he committed this violation while on bond. He has several felonies on his record, including, as I noted, prior prison. He has a mixture of PVs and PRC violations. I believe he went to prison, sent back to prison at least twice on PRC violations. Has also violated a civil protection order. Also has now 3 warrants out for him. They're only for traffic, but again, not really seemingly willing to answer for those. Doesn't seem to take responsibility, Your Honor. Doesn't really take responsibility even for this matter. According to the PSR, my reading is that he lays it at the feet of his co-defendant largely. Also, in that vein, in terms of taking responsibility, he had an institutional infraction in the jail where he was caught lying. Apparently, it was a violation, and he said it wasn't true, but of course, it was caught on camera. Again, caught on camera once again, just like he was in this particular instance with regard to the wallet. Your Honor, it's the state's position that, in totality, it appears that prison is probably the better of the 2 options. However, we would respect and, of course, trust the court's discretion if NeoCap were to be ordered. I would also like to indicate that there is being held by the police department some $269 that the victim, the owner of the wallet, said he had in that wallet. And we would ask that the defendant actually give up all right, title, and interest in that cash totaling $269, Your Honor.
No. There's no forfeiture on here or anything, is there?
There is not, Your Honor.
I can't order it. I mean, I could order restitution. And if it's collected as evidence, once it's... Well, that's up for the police to determine that.
All right, Your Honor.
This court reviewed pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here today. All this is considered by the court only the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. Give me 1 second, please. There was no victim impact statement received, correct? All the foregoing that I mentioned is considered by the court only the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, nothing stands out factually indicating the offense is more or less serious than what normally constitutes the commission of the offense. As for recidivism factors, many of these factors, however, are present. The defendant has a history of criminal convictions. He has previously served a prison term. He has not responded favorably. This is the biggest problem I have. To previously imposed sanctions by courts and agencies. He's been on parole, post-release control. He violated multiple times and was sent back to prison. That rarely happens, but with this defendant, it happened multiple times. He's been on probation for other offenses and he's violated. He just got released from parole literally a couple weeks at the most before this offense was committed. No factors indicate recidivism is less likely. I'm not sure about genuine remorse. It speaks well, but when he had an opportunity to talk to the probation department, he didn't acknowledge taking the credit cards. So he took cash out and left the wallet there. So I don't know how forthcoming he has been. Under 29-13B1, the court finds the defendant committed his prior prison term. Also did commit the offense under the recidivism factors while he was on bond for another case. Considering all these factors, particularly the recidivism factors, prison is certainly consistent with the purposes and principles of sentencing. With the nature of the offense, I'll give the defendant one chance to prove what he says. He says he can do this. He's ready, so I'll give him one chance. I'm going to find he's amenable to an available community control sanction, but that sanction that is available into this court, it's the only one that's really available, is a completing the program at NeoCap. So I'm going to put the defendant on community control sanctions for 2 years. I'm going to order that he serve 125 days in jail. He has credit for 66. I'm going to order that he enter and successfully complete the program at NeoCap, and as soon as the bed's available at NeoCap, he's to be released from the jail to go to NeoCap. Any remaining jail time will be vacated. To successfully complete that program, follow all aftercare recommendations. After jail, I'm going to order, now you very well may not have to do this, but you're going to return to jail for 30 days in the transitional day reporting program. Again, you may not, good chance you won't have to do that, but what that is, it's a program that helps people make the transition from being locked up to being on their own. Instead of just opening the doors and saying, all right, you're free to go, a lot of people have nowhere to go. But if you have housing lined up, if you have work lined up, and that's all set, and yet stuff you can work on while you're in NeoCap and getting it ready to go, I'll vacate those 30 days. You won't have to do it. Some people need that assistance in making that transition, so I put it in place for everybody that goes to NeoCap. Most of the time I do vacate it. But if that stuff's lined up for you, I'll vacate it for you as well. Other conditions, you're not to use any drugs or alcohol. Must submit random urine screens. They have to be negative. Positive screens a violation. You're to obtain and maintain full-time employment. Pay court costs and supervision fees. Not to, I'll strike that. Not to have any contact with the co-defendant here. Her name for the record is Anquinette Likes. As far as restitution goes, I didn't get a victim impact statement. I mean, I'm not going to order that the property that was seized be given to the victim. I mean, first of all, it was found in the other defendant's purse. Some of it. I can't order that happen in this case. far as restitution goes, I mean, the victim not testified, but provided a statement to the police that there was at least $269. This could be more, but I'm not going to order more, but I'm going to order $269 of restitution. Ms. Crook, is there anything else I should be considering here?
Nothing else, Your Honor. Thank
So,
you.
Mr. Buchanan, you understand the conditions of your probation?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including jail time. Or I could terminate your probation and send you to prison. If I did that, it'd be 12 months, and that would be consecutive to any other sentence you may be serving at that time for something else, or that you're being sentenced to for any new case that, if you were to pick that up. You understand that?
Yes, sir.
All right. Mr. Devanchi, anything else for the record?
Just for my clarity, Your Honor, you did order $269 of
Yes.
restitution? Thank you.
Ms. Thomas, anything else?
No, Your Honor, thank you.
Thank you. Ms. Bell.
Thank you, Your Honor. We're here today in the state of Ohio versus Regina Patterson, case number 24CR736. The defendant is present with counsel Bill Watson, and we're set today for a sentencing hearing. We were last before you on June 30th, and at that time, the defendant pled guilty to 5 different counts, all related to drug possession. Counts 1 and 2 being possession of cocaine, felonies of the 5th degree. Counts 3 and 4 being aggravated possession of drugs, felonies of the 5th degree, and count 5 being possession of a fentanyl-related compound, also a felony of the 5th degree, and they all carried forfeiture specifications. During that time, the pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed. There is no agreement as to sentencing, and the defendant has 74 days of jail time credit.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. Ms. Patterson is still a young woman who, in my opinion, has a very bright future ahead of her. I think she's a bright woman. I've talked to her numerous times. Her family's here in support of her. Unfortunately, Your Honor, as I know this court has seen numerous times, Ms. Patterson is an individual with a very bad drug problem. She had a good job here locally in Mentor and Lake County, but drugs really took a hold of her. When this case first came down, I sat down with Ms. Patterson. We went through some available options. Due to her lack of a felony history, I felt she would be a good fit for the intervention in lieu program. I filed a motion for that. Ms. Patterson at the time, at least to my face, was telling me she was looking forward to it, but unbeknownst to myself, again, her addiction got the best of her. As this court already knows, she absconded, she didn't show up, she was out for quite a while. Although she was here in Lake County, there was a warrant out for her that whole time. She did not show up. She was picked up a little over a couple months ago, in May, and at that time, again, to show the court what a bad drug problem she has, she tested positive for a lot of different things. That being said, Your Honor, she's sat in county now for a while. She's sobered up. She's got a clear head. And again, I've talked to her, and she's told me that she wants to be done with that part of her life. She is looking forward to treatment, hopefully, if this court will consider it. She's looking forward to working on herself, hopefully, eventually one day, getting back with her family, and hopefully one day getting back to work and being a productive member of society. She knows she's got a long way to go, and I know this court has a lot of discretion this afternoon as to what direction it can do with sentencing, but I'm going to respectfully ask the court to take into consideration her lack of a felony history here and her sincere desire to permanently sober up. You're going to hear from her in just a second, Your Honor. I think she's sincere. I'm respectfully asking the court to take those factors into consideration. Thank you, Your Honor.
Thank you. Well, Ms. Patterson, you do have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, sir. Your Honor, first and foremost, I would like to apologize to you and the courts for wasting time and money as a result for missing my original court dates. Although these very well may sound like excuses, the truth is I was scared. I was scared of missing Christmas, scared of going to jail, but most of all, I was scared of detoxing in jail. But looking back, I'm not quite sure what I was really afraid of, because it was most definitely inevitable and it was very much needed. I want to take full accountability for my actions. Being in jail with a clear mind has had me thinking and realizing how messed up my actions were and how real my addiction was. I do not want to return to that lifestyle ever again, and I know there's a lot more to life than just getting high. I have lived it. I was once an upstanding citizen. I had my own home, a driver's license, my own vehicle, and a great job. I was a wonderful mother, daughter, sister, and friend. With your help and treatment, I guarantee I can be that person once again. I have a lot of love to give and receive, and with some assistance, I cannot go wrong. I truly have the best support system, and I will not ever let them down again. I look forward to being able to put all of this behind me and to living the remainder of my life a successful member of society and live life to the fullest. Thank you.
Thank you, Ms. Patterson. Mr. Watson, anything else you'd like to say?
Nothing further, Your Honor.
Ms. Bell, for the state of Ohio?
Thank you, Your Honor. So the state was certainly disappointed at the events that happened last year with Ms. Patterson failing to participate in the intervention program, failing to appear for that hearing. However, the state did have the opportunity to review the pre-sentence report in this case. I felt as though Ms. Patterson took responsibility for what happened, for her actions. She also does not have a very long criminal history, which is why she was a candidate for ILC. And she has a problem, so the state would be recommending some sort of community control sanction to include either jail treatment and or NeoCap. Thank you.
Well, this court did review the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances. Of the offense involved, the nature of the offense. I've considered everything that's been said here today by Ms. Patterson herself, Mr. Watson, the prosecutor, requests and recommendations from everybody. All of this is considered under the purposes and principles of felony sentencing, which are set forth in 29 and 2911. As for the factors in 29, 2912, factors indicating the conduct is more or less serious. There's nothing that stands out factually about this case which would indicate it's any more or less serious than what normally constitutes the commission of these offenses. As for the recidivism factors, indicating recidivism is more likely. Defendant does have a history, albeit brief, but a criminal history. Nothing until 2022. So you're 36 now? 37 maybe? 37?
36.
33 years, first 33 years, nothing. There are 2 prior convictions. She did violate the conditions of her bond in failing to appear, getting to report to probation. That's a factor indicating recidivism is more likely. Factors indicating it's less likely. It's not really the factor. Usually if someone commits a crime years ago and then they led a law-abiding life for a significant number of years up until this point, we have like the opposite here, but I find that is relevant. Again, for 33 years, she didn't have anything on her record, and then something happened. No, I know you're using longer than that, before that, maybe.
To be honest, I wasn't. I started late. It sounds funny, but
That's not what you said. I mean, when I say I know that's because I'm looking at what you told the probation department.
Okay, all right, I understand. I'm thinking of one particular thing, but yeah.
Yeah, maybe not the
No, I understand what you're
fentanyl.
saying.
I'm
I
talking about the
apologize.
smoking. I mean, that's been going on for a long time. Now, it's
understand what
certainly
you're
not.
I understand what you're saying. No, I
Okay.
apologize. You're correct.
Yeah, apologize, but. Anyway, that's a factor indicating recidivism is less likely to me, the fact that it was crime-free for so long. What started 3 years ago that caused the usage of the drug that's caused you all the problems?
It was a toxic relationship. I was with somebody for 15 years, and it just like halfway through it got really toxic. And I'm not trying to make excuses, but that's
I'm not
exactly
saying you
what
are.
happened.
I'm
I mean,
asking
it was a bad time in my life. I was with somebody for so long, and then it just turned bad, and I couldn't get away from it. And
I'll ask you. I'll tell you exactly why I'm asking. Is your work environment have anything to do with that? I mean, you're just working in bars. and which is nothing wrong with it, and
No,
you did a
yeah.
great job. But it's a different environment than other positions, and
I would say, I mean, at the beginning maybe, but this last job that I had, Mean Mugs, I'll be honest with you, nobody did drugs, and it was kind of crazy to me because in that restaurant, restaurant business, it comes with the territory.
well, that's why I was asking, because I don't know if you should be doing that initially, perhaps, since you should stay out of that environment, and that's why I was wondering whether,
Understood.
that's what I was asking. There does appear to be genuine remorse, and that's a factor indicating recidivism is less likely. She did violate condition of bond, which would be a factor which would override a presumption for community control. However, the court finds community control is, I should say, prison is not consistent with the purposes and principles of the sentencing. The defendant is amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions and give you a chance here, Ms. Patterson, for a period of 2 years. I'm going to order that you serve 120 days in jail. You have credit for 74. I'm going to order that you immediately get into the jail treatment program, successfully complete that program. Upon completion of that program, you will enter and successfully complete the program at NeoCap. As soon as a bed's available, you'll be released from the jail after you complete JTP. Go to NeoCap, complete that program. It's a good program. Take advantage of it. Follow all their recommendations. After NeoCap, you most likely aren't going to have to do this, but you're going to return to jail for 30 days for the Transitional Day Reporting Program. But again, it's unlikely you'll have to do that. Transitional Day Reporting Program is a program which helps people make the transition from being locked up to being on their own. Many people, when they're released from custody, have nowhere to go. They have nowhere to live, nowhere to work. So that this is a program where they're in jail for 30 days, but they get released during the day to go find housing, to go find employment. If all that's lined up for you at that point when you get done with NeoCap and it's something you can work on while you're there, you won't have to do that. It'll be vacated. But I put it in place for everybody in case you find yourself in that position. The other conditions then are just going to be not to use any drugs or alcohol. That includes marijuana. Submit random urine screens. They have to be negative. 3A meetings a week with the sponsor. To obtain and maintain full-time employment. I'm going to have you at some point, whether it's done at NeoCap or after, obtain a mental health evaluation and just see what, if any, recommendations they make for any type of counseling or treatment. If they say there's nothing needed, then you're good. If they say it could be helpful to meet with someone once a week, once a month, whatever it is, then follow their recommendations. You're to take all medications as prescribed. You're to have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too, but only the doctors that you tell probation about can give you prescriptions. If you get a prescription from some other doctor that they're not aware of, that'd be a violation. You can only get them filled at one pharmacy. They need to know where that is as well. Sign whatever releases they request so that they can contact these folks if necessary. Pay court costs and supervision fees. I'm going to order the forfeiture, the contraband, and instrumentalities. Derek, is there anything else I'm missing or omitting here?
No, Your Honor. Thank you.
So, Ms. Patterson, you understand all the conditions of community control that have been put in place?
Yes, sir.
Any questions for me?
Okay.
All right, I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions, including jail time, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months on each of the counts. The order's consecutive, so 60 months in prison hanging over your head. You understand that?
I understand.
All right. That covers everything. Ms. Bell, is there anything else for the record?
Just a bond defendant would be released, Your Honor.
Well, there is no, I mean, bond was forfeited initially.
Sorry, yes.
So
that
I'm
is
not
correct.
going, that's not going to get released, and then I don't think there's been a bond since then. So don't put anything in there about bond.
Thank
Mr.
you.
Watson, anything else?
Nothing further, Your Honor.
Thank you.
All rise.
Ms. Cutts.
Thank you, Your Honor. We are today in the state of Ohio versus Yazan Albana, case number 25 CR 000-094. Defendant is present in open court today with his counsel, Timothy Deeb and Jay Schlackett. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on June 26 of 2025, where he pled guilty to count 3, menacing by stalking, a felony of the 4th degree, count 4, attempted disrupting public services, a felony of the 5th degree, and the lesser included offense of count 5, domestic violence, a misdemeanor of the 1st degree. At that time, a pre-sentence report and victim impact statement were ordered. It's the state's understanding that those were completed and have been provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you. Mr. Schlackett, any reason not to go forward with sentencing?
None, Your Honor. Thank you.
Anything you would like to say on behalf of your client at this time?
Judge, before Mr. Deeb and I prepare any remarks regarding some mitigatory comments for this young man, would you please accept a statement from his cousin, Sam Salah, S-A-L-A-H.
Sure. Mr. Salah, you can just stand right there, state your full name. You just spelled it, so I appreciate that. But keep your voice up so that we can all hear you, and it's being recorded, so make sure you do that.
Hello, Your Honor. My name is Sam Saleh. I am Yazan's older cousin, and Yazan has been like a little brother to me since we grew up together. And he's a very good man, very full of life. He's very positive, very harmless. I know the tempers flared that day, and we all want to make this right. I believe he did learn his lesson. I talk to him every day while he's in there, and he's very sorrow and very, remorseful for what he's done. And you would please, if Your Honor, if you could please release him today, we would all be very helpful. And anything else beyond that, we'll house arrest, whatever you'd like to do. But please, if Your Honor, we will make sure that this kid will be on the right path after this. And I know himself is very sorry for this whole mess and everything that's happened. And he couldn't wait for his son to come out and for all this to happen. It's a very sad situation, and we're all here to support him. We love him. Nobody's here for show. Everybody's here because we love him, and we want to make sure, hopefully everything, you can make your decision on all of the support and help that he will get if he comes out. Thank you, Your Honor.
Thank you. Mr. Schlackett?
Thank you, Your Honor. May it please the court, on behalf of Mr. Albana, Mr. Deeb and I did take the opportunity to present a sentencing memorandum. We truly like to thank you, Your Honor. I know the court's very busy, and you took the time to read everything, including our sentencing memorandum. I know that I had reflected in there that he had no prior record. I just overlooked the fact that he had these misdemeanor marijuana case several years ago and a paraphernalia, which was probably a pipe or rolling papers. As you know, Your Honor, he's 25 years old. He's here with all his family. His father is the owner of a place called Prince Tire. I don't know if you've ever driven by it in Willoughby. But Yazan really completely operates it on his own. I mean, it's his business, although he's not the legal owner. The business is certainly having some problems with him not being there, but these are all collateral consequences of decision-making in our lives, and he got nobody to blame but himself, and he's certainly not blaming you. As you know, Your Honor, he was remanded for violating the terms and conditions of his bond because he tested positive for marijuana. He's been now with jail time credit from the couple days before and the days since remanding. He's got 29 days in on this F4, the F5, and the misdemeanor. Judge, I looked at all the sentencing factors and kind of highlighted them under 29, 29, 11, 12, and 13. I think that you could possibly say, well, the relationship facilitated the offense, but that's kind of part and parcel of every domestic violence and things of a relationship issue.
Well, the domestic violence is the misdemeanor here. The other ones
Yes.
are felonies.
It is a misdemeanor. The other felony, Your Honor, is taking a phone where they were arguing over a phone, and then, of course, it's a pattern of where they'd had some disagreements.
It's the stalking case.
Pardon me?
That's the stalking case.
Yes, that's
the charge,
the
I should say.
Yeah, that's the stalking case. Judge, I don't know what else to say except as a first offender, having done almost a month, I know that the court has some concerns after we'll hear from probation or hearing from probation, that it appears superficially that this young man has not accepted responsibility. I can tell you, Judge, that just culturally for him, it's very difficult to go out into the community in front of his family and his parents and his friends and admit that he committed these crimes. I think it's frankly, Judge, hard for him to say it to himself, but he clearly has accepted responsibility. You're going to hear his acceptance of responsibility, which was not coached by either Mr. Deeb or myself. It's going to be a heartfelt, from his soul, Your Honor, apology. He dearly loves the victim in this case. He has not been able to have any relationship with his baby. And again, I'm not saying woe is me, Judge. These are all consequences of what happened that night, and he knows it. I'd ask Your Honor to consider a community control sanction. I think with proper rehabilitative services that your wonderful probation department can render for this young man, it's going to be much better than just housing him in a facility where any counseling or any help, and then he just comes out and he's in the same place he was before. He could certainly use anger management. He could certainly use some parenting classes. He has to learn how to deal with life stress in relationships and not allow things to get physical. No matter what, he can get physical. And I think he knows. So, Your Honor, I would submit most respectfully that a community control sanction would not demean the seriousness of the offense, and through adequate programming, it will ensure that this young man does not reoffend. And we're going to ask you, Judge, if you could exercise your discretion to grant him a community control sanction. You know, normally if it hadn't been defined as a crime of violence under 2929.01, he'd be an excellent candidate. I mean, it'd be almost a slam dunk, as they say. But these are crimes of violence, and he knows it. And certainly if you exercise your discretion to send him to prison, he's going to have to just go do his time. And he knows it. He's been thinking about that for the last days. Nothing else in his life is he's consumed with trying to make certain that you understand he gets it. And Judge, I think this is one man who, if you give him a break, he's not going to disappoint this court. Thank you.
Thank you. Mr. Deeb?
Your Honor. One other thing that we would like to address, Your Honor, is yes, we'd like to be in his son's life, and also in Destiny's that you would have it so they can co-parent at the very least together. So we'd ask that the no contact be removed. I believe that both parties want that, but we're definitely asking on behalf of Mr. Albana that he be able to communicate and see.
Wasn't there a TPO?
It's a temporary protection order in addition to the no contact on the bond. But he would like those removed so that
where was
become family. From Willoughby Municipal Court.
As at the time when with the domestic violence?
At the time of the arraignment.
So it's not a separate.
It's in this case. No, it's
oh,
not
it's in this case. Gotcha. All right.
It's not something to the common police court. It just came with this case as
gotcha.
From the Willoughby Municipal Court.
Judge, I believe it was a criminal protection order.
Right. I got it now. I mean, that goes away when the case is over. Right. I thought it was a separate order that was obtained through filing of a motion for that.
Thank you, Your Honor.
You're welcome. Mr. Albana, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor. I'm not good with my work, Your Honor. I had a lot of sleepless nights here, Your Honor. I take full responsibilities and actions and realize how I hurt my love of my life. I love myself, my family, and my loved ones. I will comply with whatever sentences you tell me to, Your Honor. I just want to be a better me. I'll do whatever you tell me I have to do. Your Honor, I promise you, you'll never see me here again, Your Honor. I promise you that. I just want to see my son. I never seen my son yet. I'm going to meet him.
Please be quiet. Go ahead.
I'm sorry, Your Honor. I'm not good with my words.
That wasn't directed to you. That was to the folks in the back.
If I was good with my words, you'll understand how sorry I am. I take full responsibility for everything. I'm ashamed of it. I'm embarrassed, Your Honor.
Thank you.
That's all, Your Honor.
stand. I don't want to get up in front of everybody.
Thank you.
You need to be quiet in the back, please. Cuts for the state of Ohio.
Thank you, Your Honor. Your Honor, this is a case that is not a one-time incident. As this court is aware, this defendant pled guilty to menacing by stalking, which requires a pattern. As the count indicates, timeframes were honored between January 1st of 2024 and the 7th of 2025. In addition to the incident that occurred on January 7th that brought the police to the home that the defendant and Ms. Williams were sharing at that time, there were other incidents where the victim had taken pictures of injuries that she had sustained from the defendant, from black eyes to redness, from bruises and scratches. There are various pictures of those and incidents that had continued on. They had lived together at first at his family's home, and then they moved into a home on their own. On this incident, the night before the police were called, the defendant had thrown a phone at Ms. Williams and struck her in the head, cutting her head. And then in the morning later that day, there was another confrontation where he bit her, he slapped her, he pulled her hair, things of that nature. The police were called. There was somewhat of a confusion. It was an accidental calling, but the police arrived and spoke with Ms. Williams, who initially didn't indicate that anything had happened, but the police were aware that something had happened based on the visible injuries on her face. So they spoke with her. She did tell them what had been occurring. What makes this case more concerning or more serious than many is that at the time of the January incident, Ms. Williams was pregnant with the defendant's child. She was approximately 7-8 months pregnant while all of this was going on. So this incident occurred on January 7th. She went into the hospital on January 13th and had their son on January 15th. She was, my understanding, approximately 7 weeks early. So obviously that was a concern. As has been mentioned, the relationship did facilitate the offenses. And yes, that is part of what the domestic violence charge has, but menacing by stalking does not require that connection. So we do feel that is a factor that makes it more serious. And obviously they live together and they now have a child together at that point. She was pregnant with their son. Defendant does not have an extensive criminal history, as has been alluded to in 2020. He had a possession of marijuana, drug paraphernalia, and possession of marijuana, and then in 2021, a possession of marijuana. That is concerning in the fact that the defendant, after he pled guilty, did test positive for marijuana on June 26th of 2025. So he did violate his bond, and his bond was revoked. Also, during the time frame, there's been a no contact and a temporary protection order in place. And during that time, though the state has not been told that there was direct contact, the defendant did post on Snapchat.
Yeah, I'm not considering this at all, this issue.
Okay.
If you felt that way, then you should have done something about that.
Obviously, the state is concerned about, in the pre-sentence report, there was some denying and minimization that occurred, as well as in the sentencing memorandum, indications regarding the victim initiating and things of that nature. We're obviously here today for the charges that the defendant pled guilty to, and those are concerning in and of themselves. So we do think, based on all the information, there's an argument that prison is consistent. However, we do understand that the defendant this is his first felony, and he did plead guilty at this stage. If the court does believe he is amenable, we would ask that he be ordered to complete the jail treatment program, decision point program, that he take anger management classes and complete those, that he have a mental health evaluation and follow any recommendations, that he does engage in parenting classes, that he obtain his GED, that he not use any drugs or alcohol, and that all periodic screens come back negative, that he have one doctor, one dentist, and one pharmacy, that he sign releases, that he engaged in full-time work. We are asking for no contact with Destiny Williams. She is going to address the court. She may have different views on that, but that is the state's position, and that the defendant, if he's given this opportunity, be made aware that if he does violate, the prison does then become a possibility for him again. And that would be the state's position at this time.
Thank you. This court has reviewed the...
Your Honor, I'm sorry. Ms. Williams does wish to speak.
Oh, okay. Sorry? Okay. Where's that? Ms. Williams, you can just take your time, stand right there, state your full name, please, so it's clear who's speaking, and go ahead and say whatever you'd like me to know.
My name's Destiny Williams. I don't know, I wrote some stuff down because I didn't want to leave anything out that I had to say, if that's okay.
You can do whatever you want. You can read something. If you need your phone, you can use that if you have to. Take your time and say whatever you want me to know.
My name is Destiny Williams, and I'm here today as the mother of our 6-month-old son, Safe. This journey of being a first-time mom has been incredibly emotional, challenging, and life-changing. I never imagined of having to do it without his father being present. But that has been my reality from day one. This case started during a time when I was upset, angry, and overwhelmed. And while what happened between us can't be erased, I've had time to reflect as a mother, as a woman, and as someone who genuinely wants to build a better future, not stay stuck in the past. I want to be clear, I'm not here to excuse anyone's actions, but I'm also not standing here today to paint myself as a victim. I've done a lot of healing, and I've come to a place where I've chosen forgiveness. Not just for him, but for myself too. Carrying anger and resentment only wastes them the future I'm trying to build for our son. The fact that he has already missed the birth of his first ever child. Not only that, but the first 6 months of his life, moments that can never be relived, is a consequence in itself. He has not even had the chance to meet our baby yet, and I do truly believe that's a powerful punishment in itself. One that has left an empty space in both of their lives. I know some people on my side might not understand or even support where I stand today. But I'm speaking today from a place of clarity and love and genuine desire to move forward in peace. Your Honor, with all of that being said, I do not want to see him go to jail. I ask, can we please work something out if possible, something that allows him to take responsibility but also leaves room for growth, for healing, and for the chance to be a father to Safe. I truly believe that would be taking a step forward, and it would be the best for everyone involved. Thank you.
Thank you.
And I also, I don't know if she told you or not, but the no contact order, I'm okay. Like, I want to have contact with him. I want to talk to him. I want to be able to talk to him about our son. I want him to meet him. I'm not saying get back together with him, but I just, that's everything that I had to say.
Thank you. This court has reviewed the pre-sentence report and investigation, the victim impact statement that I received. I received the sentencing memorandum, read and taken that into consideration. I've considered everything that's been said here today in open court by Mr. Schlackett, Mr. Deeb, the defendant himself, the relative that spoke on his behalf, cousin, I believe, older cousin, prosecutor's comments, recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, court notes that in regards to the stalking charge, the relationship with the victim did facilitate the offense. Court also notes that the defendant was pregnant during the commission of at least part of the stalking, but the domestic violence for sure. So her condition, physical condition, exacerbated, injuries exacerbated due to the physical condition of the victim. No factors make it less serious. As for recidivism factors, the court notes there are the 2 prior convictions for the small misdemeanor charges involving marijuana. In regards to marijuana use, I'm not saying it's related to this offense at all, but there does appear to be an issue there, more so than the defendant acknowledges. He says it's not an issue for him at all, yet there's 2 convictions on your record related to marijuana use. A condition of your bond was that you don't use marijuana, and you went ahead and used it anyway. So that means one of 2 things. There's an issue there with it, and you couldn't help yourself with using it, or you don't care what the judge said or the court said in regards to no use of it. You went ahead and used it anyway. Those are only 2 options there are. There was a condition of your bond and your liberty was at stake, and you went ahead and used it, knowing that if you did, your bond could be revoked. You also claim they have the medical marijuana card. You've never used it. You've never used it to get any marijuana. So that's irrelevant. In regards to remorse, I'm not going to say there's not genuine remorse, but he certainly wasn't forthcoming with the probation department when he spoke with him. And you talk about how you're not good with words. Well, your words, they weren't confusing at all because they were the exact opposite of what you're saying now. You said, I did not put my hands on his girlfriend. You pled because you didn't want to take it to trial and make it worse. You tried to leave and she was attacking you. Those were your words. That's like 180 degrees opposite from what you're claiming that you did. You didn't take responsibility with the probation department. You then come in and say, I want to take full responsibility, but then you say what I just said. Whose phone is that? The phone should be turned off. She would not open the bedroom door, and when she did, her hand flew back and her hand was close to his mouth, and she ran into your mouth. That's how apparently she got bit, because she ran into your mouth. You didn't say you did anything to her here. That's not accepting responsibility. And this isn't a one-time incident. The felony charge of menacing by stalking you pled to involves conduct that occurred over a year's period of time. As for factors indicating recidivism is less likely, the court does note that aside from the 2 minor misdemeanor, I don't know if they were minor misdemeanors, but they weren't minor misdemeanors, they were low-level misdemeanors. Marijuana charges, there's nothing else on his history. And that's a factor indicating recidivism is less likely. Under 2913B1, the defendant did cause physical harm to a person. That overrides any presumption for probation and permits the court to impose a prison sentence without having to make any findings in that regard, or excuse me, any findings to overcome a presumption. Prison, however, at this point, based on the defendant's history, is not consistent with the purposes and principles of sentencing, and I will give you a chance, despite what I find to be your lack of accepting responsibility here. I find you're amenable to an available community control sanction, but if that's how you truly believe, and you don't think you did anything wrong here, you're going to have a difficult time succeeding on probation, because you're going to be required to do certain things, and you're going to be feeling like I shouldn't have to be doing these things because I didn't do anything wrong. And if that happens, we're going to be back here. I hope that's not the case. I'm not saying it's going to be the case, but typically when someone doesn't think they did anything wrong and they're required to do things that they don't really want to do, that's what happens. I'm going to put you on community control sanctions for a period of 2 years. There's going to be consequences, though. You assaulted an 8-month pregnant woman. Not just going to ignore that. And that's not even talking about whatever happened, the stalking stuff that happened for a year. Putting on community control sanctions for a period of 2 years, you're going to be ordered to serve 90 days in the jail. You have credit for 29 days you've already served. You're going to enter and successfully complete the jail treatment program, as well as the decision points program. Upon conclusion of that, you are to have no use of any drugs or alcohol, and that includes no marijuana use. You're to submit random urine screens. They must be negative. I want you to follow whatever aftercare recommendations are from JDP. I'm not going to order any specific AA meetings. If they say you need to do some, those will be conditions of your probation. If they say it's not necessary, then I won't make you do them. Whatever recommendations come from JTP will be, in regards to AA meetings, will be a condition of your bond. You're to obtain and maintain full-time employment. You mentioned wanting to get your GED. Is that something you really want to do?
I would definitely do it, yes,
Well, then
sir.
I'm going to order that you at least make a reasonable effort at obtaining your GED. To obtain anger management counseling. Pay your court costs and supervision fees. Where's the probation officer? Oh, Derek. Sorry. Derek, is there anything else I'm missing here I should be considering?
The only thing up in the air would be the no contact.
Well, I'm not ordering that at this point. Victim came in here and says she doesn't want that. I'm not ordering it. Mr. Albani, understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
You'll never ever see me here again, I promise you, Your Honor.
All right, I want to know if you have any questions for me.
No, Your Honor.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 18 months on count 3, an additional 12 months on count 4 to be served consecutive to each other for a total of 30 months in prison. You understand that?
Yes,
And that would be consecutive to any other sentence that you may be serving at that time for something else, or that you're being sentenced to. I will further dismiss the rest of the charges in the indictment, and I'm going to order the release of defendant's bond. It's not being forfeited, so your bond will be released.
Thank you, Your Honor.
I'll be released.
Your bond is released.
Mr. Schlacker, Mr. Deeb, anything else?
I'll just say thank you, nothing further, Your Honor.
Ms. Cutts.
Your Honor, I just want to clarify two things. Is the community control sanctions concurrent on each count?
Yes, yes.
And you had mentioned, you had said anger management counseling. I didn't know if you meant anger management and counseling.
No,
or that
anger
was
management.
Counseling? Okay.
Just anger management.
Thank you.
I mean, they'll address whatever other issues there, if they think there's something there.
Understood.